because we're swerving from everything we've heard about these various ESG topics with regards to commercial arbitration, investment arbitration, now right into the very center of what is often referred to as the phenomenon of climate litigation, looking at challenges and financing of administrative, public, particularly public claims relating to ESG and sustainability matters. And to address the topic, we have two predestined speakers. We have, on the one hand, once more Alice to give the funder's perspective, and coming onto the panel now, and finally, by way of introductions, Michaela Krömer, who is a practicing lawyer with degrees from the University of Vienna and Harvard Law School, and she is the most eminent Austrian climate lawyer, leading the first Austrian climate case and now representing, if you've been following the news, the first case of the so-called youth cases that have been popping up all across Europe now on their litigation on the basis of the UN Convention on the Rights of the Child and its constitutional implementation in Austria. She's a thought leader on climate law and migration law and sits on a number of supervisory boards. Without much further ado, Michaela and Alice, you have the floor.
Hello, a warm welcome from my side, and thank you very much for this very kind introduction. Maybe to quote Monty Python, now it's onto something completely different, so don't be surprised. Me and Alice, we really wanted to just flesh out a few practical approaches and issues regarding public litigation claims. And given the fact that almost a year ago, namely on the 23rd of February 2022, the Commission published its first proposal on the Corporate Sustainability Due Diligence Directive, CSDD, hope I get it correctly, I thought it would be appropriate to start off there. What we know about it, what we don't know about it, what does it mean from a movement lawyer, as I sometimes like to call myself. And then I'd love to move on briefly to climate litigation, just sketching out some ideas and what is going on in the field on a very high level, because it's late in the evening and we are online and I know it's difficult to follow. So thank you very much in advance already for your attention. When it comes to the enforcement mechanism of the CSDD, one could say that it's basically based on two pillars. It's a public enforcement mechanism and it's a civil enforcement, a private enforcement mechanism. There is an interrelation between the two, but how that exactly works out in practice is one of the things that is still unclear. So I'm not going to say much about it, just introducing you those two pillars, and we'll see how they will enforce each other or they won't. But usually that's what happens. Anything that happens in the public sphere influences your ability to file cases in a private sphere. And that's something that me and Alice really want to bring home in this 25 minutes. If you look at the article, then there's actually just only a few that are really relevant when it comes from a litigation perspective. And that is, on the one hand, the duties that are enshrined on Article 7 and Article 8, have a reference to annexes. And then on the various public and private enforcement clauses. So what about the elephant in the room, the big question, how is that going to turn out in practice? Maybe let me just tell you that negotiations are still in progress. Currently, it's up to the Parliament to discuss the proposal. There are various committees who have released new amendment proposals, and we will see what the Parliament eventually will come up with end of April, beginning of May. So we have a public enforcement mechanism, and maybe the thing that comes to mind would be the General Data Protection Regulation, in a sense that it also has a very strong public enforcement mechanism, and that's particularly due to the fact that they are very high sanctions. The sanctions in the CDPR are about 2% of the global annual turnover, or 10 million euros, depending on which is higher. Now, the current directive doesn't foresee any minimum sanction. It leaves it up to the member states as is. And that will obviously have a big effect on what type of sanctions member states will put into play, or maybe if in the course of the negotiation something will become clearer what the actual target here is. But given that we do have the CDRP, a lot of people would expect something along those lines, sanctions that matter. From the civil society perspective, one thing that's important when it comes to the public sanction mechanism is that they also want to make sure that reports can be made anonymously, that people who make these reports do not face any personal challenges, also given power imbalances that one might face when it comes to human rights violations. The second part, and that's probably more interesting for the panel, would be the civil law. Everything okay, Alice? Okay, sorry. Would be the civil law perspective. So there it says that basically NGOs and private people can file if one of these duties has been infringed by companies. Maybe what are these duties? I haven't spoken about that. It's basically to identify, prevent, end, or mitigate the duties that come to environmental and human rights consequences along chains of supplies. Now, what is still unclear, and that's important from a very practical litigation perspective with the lens coming from the lens of NGOs, is that currently the directive doesn't share the responsibilities regarding the burden of proof, which makes it challenging for people, especially the ones that are at the very beginning of these supply chains and where we face the most severe human rights and environmental violations, to bring cases. Second point is, at the moment, there are no change of limitation when it comes to bringing a case. From a civil society perspective, one is proclaiming for a more extended time experience that should apply because it's difficult to establish the relevant fact patterns, to establish certain causalities, especially if there is no relief or a level of relief when it comes to the burden of proof. And the third part, and that's something that Alice is also talking about from a different perspective, is of course the financial risks. You face high financial risks in a civil law case, and especially when you as an NGO or as an individual are trying to file a case against a multinational. Currently, there is no regulation regarding the legal costs, but I know that these issues are still under debate. So one might expect some changes in the articles that have been proposed by the Commission, but who knows? Also, it's important to flag out that there's a director's duty of care. So there's a possibility of some level of personal responsibility. And all I can tell you now that whatever will happen in the end, there will be some type of civil law claim availability for civil laws. There will be a director's duty of care, and NGOs will try the most to make it work the best for them. So we will for sure see some cases to be filed, because cases like that have already been filed even without a directive. So I think that's something that, irrespective of the difficulties in practice, this is not going to stop. From a climate litigator's perspective, it's interesting to look at what does it mean regarding climate change litigation. I mentioned in the beginning that you have the duties, the obligations in Article 7 and 8, and then later on Article 17 to about 23, 24, you would have the civil and public law sanction and enforcement mechanisms. Now, the climate at the moment has its very own article, that it's Article 15, and it basically says that companies are obliged to set up a plan in compliance with the 1.5 goal of the Paris Agreement. The way it's drafted makes it very difficult for companies to actually understand what is demanded of them, especially given the fact that we're most likely not able to reach the 1.5 target any longer. So I think that's also something that needs to be considered, because you can't put any duty in place that's actually factually not impossible. But from a litigation perspective, Article 15 is not included under Article 7 and 8 yet, meaning that there is less of a chance to actually derive anything thereof. The Parliament, however, in its last committee, published a changed version of the directive, which has just happened, I think, 3 weeks ago, where they included climate duties under Article 7 and 8, hence bringing the climate back in. So I think it's, again, we are left in a waiting position to see if or if not the directive is going to push climate litigation further. From what I know, this is deliberately not the goal, but we will see. Irrespective of what happens in that directive, there's a realm of climate change litigation going on, and it's increasing given the fact that more and more cases are won. So even if chances of filing on the basis of the directive are very little or maybe unsuccessful at a preface level, you will expect climate to play an important role when you are a company working in and acting in the field of the European Union. I think one of the things that are very obvious types of climate litigation targets would be anything related to greenwashing in the widest sense, and we already see quite a few cases. So I think even in the last 4 months, about 4 or 5 cases were filed from the UK and the Netherlands, so we will definitely see an increase there. Other cases will address, and I think there we can expect cases to come regarding the use of land, the use of water, biodiversity, and general resources. And I'm just talking about cases which are basically dealing with the status quo and are not under, or some are under the revision of the European Commission, but out of any particular, let's say, legal change input. So there doesn't have to be any change of law or regulation for these cases to be triggered. And one thing that you can see is that one country starts one case, and then there is this copy-paste factor that this type of idea is taken over in another national jurisdiction and implemented there. Another last set of cases that I do think we will see happen again, even though the last one failed, would be regarding the targets of the European Union and the targets of the Green Deal and the climate law, the Climate Protection Act of the European Union. The People's Climate case, which was filed, I think 2020, it was definitely decided by the court in 2021, was filed on behalf of 10 families across the European Union, some very much currently already impacted by the consequences of the climate crisis. And the European Court of Justice denied the case, rejected it, given the lack of standing. In the field of climate litigation, I think there is the opinion that one should try again. It's not clear how, but I'm sure we will see something along these lines happening. Now, if any of these target cases is successful, everything built on these targets need to be changed. So one could expect a big change in the targets and sanction mechanism if public law cases are won. Again, all I can tell you is that there are a lot of smart people thinking about this and not giving up, because young people, and like me, we are very worried about the consequences of the climate and biodiversity crisis, also for our economies, and really trying and pushing for change. And we have already seen an impact to the supply chains by the climate crisis, and therefore I think there's a lot of people who think that climate should play a role in supply change. You can tell I'm an advocate for these cases, and I'm not going to deny that. It's a very subjective perspective I'm sharing. And maybe to round that up, I just want to briefly talk about a case that I filed 3 days ago. And to brighten up the presentation, Alice is going to share the video of the campaign. And given that it's in German, I'll just briefly going to talk you through the case. It's a case that's been filed on behalf of 12 children aged 5 to 16. And these children are challenging certain norms of the Austrian Climate Protection Act. This case is basically targeting a few Austrian specialities. One of them, that we have a Climate Protection Act that since almost more than 2 years doesn't have any reduction targets, which also makes it very complicated for companies to orient themselves when it comes to transformation. The second speciality that we have in Austria is that children, like these kids that you see here, have special constitutional rights. And these rights say that they have a right to duty of care. So it's different from the rights on the of the ECHR. It's actually within the law that they have a right to be protected. And now they're claiming these rights and saying, given these rights, the court has to grant them access to standing, access to justice, and that a climate law that doesn't have any reduction target and doesn't have an effective mechanism to set up climate transition mechanisms infringes them in their constitutional rights and their right to equality. And I think I'm hopefully good at my time, a little bit over my time. I now leave it up to Alice to talk about challenges that cases like these face, and one of them definitely is the funding thereof. Thank you very much.
No, thank you so much, really, Michaela, for this super great presentation. Yeah, sometimes we wonder as lawyers, what is the meaning of our being? Are we doing also any good except for, litigating and awarding, or being able to award damages to our clients and so on? So this is a completely different set of disputes that you're involved with, and I'm so grateful that there are lawyers out there like you who take this as a personal cause. From a funder's perspective, these sort of public claims, which are super important, are equally super difficult to fund, because as my colleagues Simon and Lucas have explained last week, what is the business model of commercial funders? It's taking over the risk, providing the financial means to pursue a claim in return for the receipt of a share of the proceeds. And here we have the problem with the sort of public claims, as you have explained. There is usually no proceeds to share. Maybe there are high sanctions that the infringing party has to pay, but in the continental European system, there are no punitive damages that can be then awarded also to the suing party, and that could be then shared with the funder. So from a very commercial perspective, and let's be very clear on this, a commercial funder is sort of a commercial entity that wants to make profit by investing into claims. It's not an NGO, but there are investors behind who really want to, see that their money is being used and they receive a return for it. So the problem that we're facing here is that actually private capital is needed to solve public problems. And the question is, how can you bring about this funding if it is not available to the parties that are suing? Well, and here we can look at the EU directive on collective redress that has sort of foreseen or suggested 3 different funding types. One is sort of classical third-party funding, which, as I have explained, is probably difficult. The second one is a suggestion that sector-specific initiatives such as claim vehicles should be set up, but they also have to receive funds from somewhere. either they receive state court funding as an initial funding and then, take it from there. But it's difficult to imagine that the state funds an entity that is then suing the state for, not adhering to certain climate change thresholds. And the third one is sort of by NGOs. And here again, the question is, how and where do they get the money from? Well, there could be special funds, philanthropic persons that, are interested in that, crowdfunding initiatives. And I think this will be probably a very important initiatives. And I was, thinking or brainstorming with my colleagues, how can also commercial funders take a share in this? And it will very much depend on the future, on the responsibility of investors, if they see it also as their, as a cause, that with the money that they provide for litigation funding, maybe a very small portion can be used also to pursue these kind of claims, where maybe they will not receive any return on their investment, but at least they can receive the investment back. And we are really thinking hard and trying to work out models that will that will provide the investors with some incentives, to go into these areas as well, out of responsibility towards the climate, the next generation, and so on. So basically, this is it from a funder's perspective. I think it is really cool to see that how law and litigation can be used in a very creative ways to, pursue a good cause. And I hope that there will be ways also to support these causes from a funder's perspective in the future.